things that are important to all of us. But I want to thank you all for being here tonight. My name is Gavin Healy. I'm the chair of the Students with Disabilities Committee of the District 2 Community Education Council. I'm excited to welcome parents, community members, our superintendent, Kelly McGuire, and all of you to this meeting today, which will be on the topic of parents' rights related to discipline in New York City public schools with special protections for students with disabilities subject to discipline. So I think the idea for this meeting and presentation came out of some data we've seen in this district about the numbers of school suspensions and disparities in frequency of suspension by disability status and by race. We know that students with disabilities make up about 20% of our students in our district, but account for closer to 50% of the suspensions. And we know that Black students make up about 8% of our students, but account for, I think, about 23 or 24% of suspensions. And I note that these disparities are not, just in our district, but they are citywide in New York City public schools. And so I hope to use this meeting to try to understand a little bit more about how to address this problem at both the individual level, with families who are encountering this process, but also at the broader level, school-wide, district-wide, and citywide. So we're very grateful and fortunate to have Rohini Singh, who is director of the School Justice Project at Advocates for Children. She's kindly agreed to share some of her expertise with us so that we can better understand this topic. So we'll start with her presentation, and after that we should have time for some Q&A and discussion, and we can unmute participants for that. And also the chat is open, so you can use that to ask questions at any time, which we can collect and address. So the floor is yours, Rohini. Thank you very much.
Thank you, Gavin. I just shared my screen. I just want to make sure, can folks see that okay? Yes, great, awesome. Well, thank you all for having me. Today, I'm going to be talking about navigating school discipline in New York City public schools. My name is Rohini Singh. I'm the director of the School Justice Project at Advocates for Children. I see some familiar names here, so I think many of you might be familiar with AFC and our work. I've been at Advocates for Children within the School Justice Project for almost 9 years now. And yeah, I really am appreciative of you all inviting me here, in part because I'm also the parent of 2 young kids, and so I get to skip the whole dinner and bedtime routine because of this presentation. So thank you for that. So today I'm going to be talking about school discipline. I'll give a quick introduction on AFC and the School Justice Project and what we do. Then I'll talk about types of suspensions and parents' rights in the suspension hearing process. I'll talk about legal protections for students with disabilities and then some key takeaways. Again, this is a Know Your Rights presentation, so I'm focusing on the specific rights of parents in New York City public schools around discipline. I'm going to be talking a little bit also about our understanding of the mechanics of how suspensions happen. I know we are joined by the superintendent here who might be able to correct me or add some more layers to that. Because we know how things are supposed to operate, but of course things might happen differently depending on the district and just the logistics or mechanics of it. But first, a little bit about Advocates for Children. Oh, I should also say that all these slides will be available to everyone after the presentation. I'll send Gavin a PDF of the slides. And so you'll have access to all the links and all the information. And then any documents I mention, like the discipline code, or when we get to protections for students with disabilities, I'll mention some documents as well. I can make sure I provide links to those to circulate. So you all have access to that after the presentation. I also will pause in the middle for questions, but if you think it might make more sense to wait to the end, we could do that as well. It is a lot of me just talking at you, so yeah, I want to give some space if folks have burning questions to ask them in the middle of the presentation. So I'll do that briefly. So first, yes, what is Advocates for Children? So we are an independent agency that protects the rights of all New York City students. Our mission is to ensure that all students have access to a high quality education. We have a number of different services. We have a citywide education helpline. I'll provide the information for that when I send around the materials. That's open Monday through Thursday, 10 to 4. where we take calls from parents, from students, from school staff sometimes about really any education-related issue, including suspension representation, suspension hearing representation. So we do a lot of, we represent a lot of students in suspension hearings every year, and we also get calls from, I mean, hundreds of families that are navigating the school discipline process. And so we have a lot of expertise and experience in school suspensions. We also, the bulk of our work is free legal services to low-income families, whether that be through suspension hearing representation or the bulk of our work is special education advocacy, as I'm sure most of you know. We also offer a number of guides and resources on our website, including a guide to school suspensions, a guide to defending suspended students, guides to protections of students with disabilities that are being disciplined. So I would direct you there for more specific information if you're navigating this yourself or helping a family to navigate it. We do a number of workshops and trainings such as this for community members, for parents, students. And then we also do policy advocacy and impact litigation. We're part of a number of citywide coalitions that are working to address suspension-related issues or discipline-related issues. And we advocate every year for more funding, for more supports, to more behavior supports, mental health supports for schools in New York City. So I lead the School Justice Project at Advocates for Children, and we help young people specifically who are facing juvenile and/or criminal justice system involvement, school suspensions, any sort of exclusion from school due to their behavior. And then we also work with young people that are either being engaging in bullying behavior or are the targets of bullying behavior to try to advocate for restorative approaches to address bullying behavior. And so just to frame this, I want to talk a little bit about why this is important and why we do this work. So there are countless studies and that had shown that students who are suspended are more likely to miss class, be held back a grade, be suspended again, drop out, and get arrested or get arrested. And this is what's known as the school to prison pipeline. I believe this has become, pretty commonplace to talk about these days, but it is really important to note that suspensions do and can have severe and lasting impacts on students' academic growth and their emotional and mental health. So suspended students are much more likely than their peers to never finish high school. And just one suspension on average can lower a student's GPA by close to 1 full point. And so again, it's really important that we put this in context and why it's important to talk about parents and students' rights in this process. A little bit about suspension data in New York City. I know Gavin had mentioned earlier that you all heard about the data in your specific district. We have access to suspension data as advocates through the Student Safety Act, which requires the Department of Education, New York City Public Schools to report on the number of removals, principal suspensions, superintendent suspensions, and then the total number of suspensions. I put this slide here to note that there has been a lot of progress over the last really decade in regards to suspensions and discipline. So even between 2018 and today, we have seen that there has been a significant and steady decline in the number of total overall suspensions, which for us is encouraging, as we're hoping that schools are choosing alternatives to exclusionary discipline to address student behavior. A note about suspension data. I know that Gavin did mention this at the beginning. While suspensions overall have declined, it is clear that disparity still exists within the data. So Black students, students with IEPs, students in temporary housing, and students in foster care receive a disproportionate number of suspensions. And again, this is citywide, but in 2023, 2024, 43% of superintendent suspensions, which are the longer term suspensions, went to students with disabilities who were 22% of the population. Black students made up less than 20% of the overall enrollment in 23-24, but received 45% of the superintendent suspensions. And in 2022, 2023, about 1 in every 32 students in shelter was suspended compared to 1 in 49 permanently housed students. And so there is some more work to do to try to identify and address why there are disparities that exist in the suspension data. And so now I'm just going to do a quick poll to see, what your familiarity is in terms of what schools can and cannot do when it comes to behavioral challenges. So the first question, if you just want to put in the chat, either true or false, I can just sort of get a sense of the consensus of the group. So the first question is, true or false, the school can call you to come pick up your child early. See some falses, some trues. I see a range, which is interesting. No idea. Um, so it's actually false. So this does happen quite a bit. Yes, if a child is sick, there are reasons why a school can call you to pick your child up early, but if it's solely for behavioral challenges, um, a school can't just call a parent and ask them to pick up their child. And so this is where, we work with a lot of families of young people that have significant behavioral challenges, and we really try to work with families and schools to advocate for more support so that students can remain in school. And so the next question is, if your child was told to be picked up early because of behavioral challenges or is out because of behavioral challenges, the school can require a doctor's approval for them to come back to school. Is that true or false? Yes, that is false. And then the next one is, I think there's kind of consensus there, which is great. So after suspension, you're required to meet with the principal before your child can come back to school. Is that true or false? Yes, that is correct. That is false. Once a student has to serve the suspension, they must be allowed back to school oftentimes, and it is best practice for principals to schedule a meeting with the family. But they can't be conditioned, the return can't be conditioned on everyone's availability for that meeting. The next one is the principal can call EMS if they think your child is a danger to themselves and others. I see some truths. This was kind of a trick question. Because it's both true and false. So yes, there are circumstances certainly that the principal can call EMS, and one of those circumstances if they think your child is a danger to themselves and others. However, the chancellor's regulation that governs calls to EMS does talk a lot about steps that principals must take before they make a call to EMS to ensure that there truly is an imminent or substantial risk of serious injury that can't be de-escalated or handled by the school. And so, the existing rules and regulations around calling EMS do really place a lot of emphasis on ensuring that that's a last resort. And so, we just like to make sure that that's known here and that you all know that that's an important part of this. And then the last one is true or false, a student can be suspended for a year. I see a mix of answers here. So, oops, sorry. So that is actually true. Prior to 2019 and the revisions in the code in 2019, it was much more common for a student to be suspended for up to a year, but there are still circumstances, very limited circumstances now, where a student can be suspended for a school year. And that is, most of those are very serious infractions. Most of them do involve possession of weapons. And also require approval from the Office of Safety and Youth Development. But it does happen. It has happened. We've had clients recently that have faced those long-term suspensions. So great. Thank you all. So I'm just going to put this slide here. I know I'm not talking necessarily to a group of lawyers, but I just want to make sure that folks know and understand that these rights are, these aren't just New York City Public Schools policies. These are enshrined in law, and these are, students and parents' legal rights when it comes to school discipline. So the federal law that governs school discipline is very broad. It comes from a Supreme Court case, Goss v. Lopez, from the 1970s, and essentially states that students must get notice and a hearing before being suspended for 10 days or more. But this case really triggered this requirement for some sort of due process protection for students that are being suspended. And then, sort of more protective is the state education law 3214, and then local laws, including New York City Chancellor's regulations, which is linked to here, and the New York City Discipline Code. I'm going to note here, I think that because I'm speaking to you all in the CEC, that this, maybe won't be an issue, but everything that I'm talking about in this presentation applies only to New York City public schools and not to charter schools. And so the specific rights that I'm talking about and the specific types of suspensions I'm talking about are, it might look different in charter schools. Again, that does not mean that there are no laws that govern charter schools. Certainly the federal law and the state laws do. But I just want to make sure you're aware that the specific processes I'm mentioning do not apply to charter schools. So types of suspensions and removals in New York City. So first, I want to make sure you all are familiar with the New York City Discipline Code. So this is the basis for all suspensions in New York City district schools. It's available on the DOE's website and should be updated annually, but has not been updated since 2019. There are two different versions for K through 5 and 6 through 12. It includes a DOE's mission statement on school climate, a student's bill of rights and responsibilities. And again, as I've been mentioning, was substantially modified in September 2019 to include a greater focus on behavioral interventions and supports. On sort of the first 25 pages of the discipline code really just talk about the different processes and the different approaches that schools should be taking for school discipline. Beginning on page 13 of the code, you'll see information on progressive discipline, as well as a glossary of positive behavior supports and interventions, and a glossary of restorative practices that schools are expected to use instead of or in addition to any sort of exclusionary discipline or suspension. And so if your child has a behavioral challenge or you're working with a student with a behavioral challenge, you can use the code to make sure that the school is using these techniques and is not just resorting to suspensions or classroom removals. Starting on page 25, you'll see different charts that list, this is sort of the top of one page. So you'll see the different levels of infractions, the specific infractions, and then at the bottom of the page, you'll see a list of discipline code supports and interventions, and then the range of possible disciplinary responses. And so you'll see that, the infraction describes generally a behavior. And so once an incident occurs, the school will then go to the discipline code and determine which infraction this falls under in order to then seek approval for this suspension. So let's talk a little bit about different types of suspensions. So there are teachers removals, principal suspensions, and superintendent suspensions. So teachers removals can be up to 4 days from a specific classroom setting. Parents have a right to ask for a meeting once their child is removed from class. They also have a right to a phone call every time a child is removed from class for behavioral reasons. And so once a parent requests that meeting, that's an opportunity for the family to talk to the school about other behavior supports, other interventions that can be put in place to address the behavior. But yes, it's that parent, the parent has to request the meeting doesn't happen automatically. But parents are entitled to a phone call when their student is removed from a class. The next sort of level up of suspensions are principal suspensions. These are shorter term suspensions for up to 5 days. These are more at the discretion of the principals. A principal must hold a conference before they issue the principal suspensions, except in specific circumstances where there might be a threat of continuing harm or danger. And parents are entitled to written notice anytime a student receives a principal suspension. And I'll get into some more detail about those in a moment. And then the next level is the superintendent suspension. And these are from 6 to 20 days or potentially more. As I mentioned, it could be up to a year for some level 5 infractions only. These require a formal hearing and written notice. And I'll go into a lot more detail about about these. And I should say that, I think that for all of these, I think you'll see in the different codes from K through 5 and 6 through 12 that especially for younger kids, principal suspensions and superintendent suspensions are only happen in very, very limited circumstances. And so a lot of the information I'm giving you will sort of be more applicable to young people that are in middle and high school. Now, it's important to note that these are the only 3 types of discipline that are allowed in New York City public schools, and no other types of removals are allowed. So if a school is calling a parent and telling them to just come pick their child up, but they haven't issued any sort of suspension, that's what we would call an illegal removal, and something that we would try to advocate to address and stop. Just a note about other types of discipline. So expulsions are very, very limited in New York City public schools. You can only be expelled if you're over 17 and you do not have an IEP. You cannot, schools, of course, cannot use corporal punishment against students. And schools also cannot transfer a student without their permission, also known as an involuntary transfer. So just to go back to principal suspensions, as I mentioned, written notice is required in the parent's language. This is by personal delivery within 24 hours. So that could be by email. Sometimes schools do put them in students' backpacks. I think we would argue that's maybe not an effective method of delivery, but it could be by fax, email, mail, or in person. It contains a statement of students' rights and should include the reasons for the suspension. And include the specific period of removal and arrangements for alternative instruction. So for all different types of suspensions, principal suspensions and superintendent suspensions, students they must receive some sort of alternative instruction, and I'll go into the details about what that entails a little bit later in the presentation. And then in addition to all these things, the notice should also have the date, time, and place of the suspension conference. And the principal suspension conference actually must occur unless, again, there's some sort of threat of danger before the suspension is actually issued. We know just from practice that this is often not the case, and this doesn't happen typically before. Parents often find out about these suspensions just with the notice that says your student is suspended for a few days because of X reason. But the principal suspension conference, the principal must attend the conference themselves. And it's supposed to be a determination of whether or not the suspension is justified. And so parents have a right to present their student's version and question witnesses. They, of course, have a right to an interpreter at this meeting. And they also have a right to discuss some sort of plan to address behavior. So this is, again, just something to note and something to monitor, that this is a point of advocacy to try to get more supports for a young person, and to maybe even try to talk to a principal about why a suspension in this specific incident might not be justified. Again, as I mentioned, principals do have a lot of discretion when it comes to principal suspensions. So, the level of success here is can be somewhat limited, but of course, sometimes getting everyone in a room and talking about what happened can be the best solution to a lot of concerns. So then finally, superintendent suspensions. So as I mentioned, written notice is required. This is a form notice, of course. So, we usually don't see issues with parents getting this notice or the information in this notice. So our understanding, and this is where I know we have a superintendent here, so you can feel free to interrupt me if I'm misstating sort of the process here. But my understanding is that an incident occurs, school does an investigation, and then they must get approval for the suspension, the superintendent suspension, before they can call the parent and notify them. And so once they get approval, schools must call a parent immediately. And then within 24 hours, a parent must get written notice of the suspension. And the suspension notice must have the reasons for the suspension, the alternative school location, details about the hearing, which must be scheduled within 5 school days, a non-binding list of witnesses that might be called by the school at the hearing to testify for the school, and then a list of parents' rights and places to call for help. So again, parents are not entitled to representation at these hearings, but they can request representation and request advocacy assistance. That list AFC just being starting with A is at the top of that list. And so we do get a lot of these calls, but a lot of the other legal services organizations, such as legal aid, legal services, Mobilization for Justice, do represent parents in suspension hearings. And so there are a number of different options in terms of places to call for help. So this is what a sample superintendent suspension notice looks like. There are many pages of legalese that are attached to this. And it's important to note, and I'll talk about this a little bit. If a parent's calling for help, the suspension notice is different than what any advocate that's going to be representing a student in suspension hearing is going to ask for, which is the suspension packet. The suspension packet contains all the evidence that the school is going to be presenting at the hearing, and parents are also entitled to a copy of that, but only upon request. And so when a student gets a superintendent suspension, this parent automatically gets this notice, which is just the notice that has again, the provision for alternate learning, and then the date, time, and place of the suspension hearing. Then in the superintendent suspension notice, you'll also get the date, time, and place of the incident, and then the specific behavior that they are alleging the student engaged in, and then a binding witness list. The things you don't get, as I mentioned with this notice, is there's no, you're not going to see just from the notice, if anybody wrote statements. You're not going to know, what specific infraction they're alleging your child has violated. So there's a lot of information here that would be helpful to know so that you can better understand how to proceed, how to move forward, whether to move forward with the hearing, or just determine how to move forward in the process. And so the first thing that we tell families when they get a superintendent suspension notice is to immediately request the suspension packet from the school. So again, this is different from the suspension notice. And the suspension packet, according to the chancellor's regulations, must be given to the family before the hearing. The family will get it automatically at the morning of the hearing, but we really push, and we've gotten a lot of support with this, to have schools provide families with a packet before the morning of the hearing so that they have time to get representation, have time to better understand what their child is being accused of, seeing all the evidence, things like that. So this contains, the packet should contain an ORS report or an occurrence report, any witness statements, including a statement, if the student that's being suspended wrote a statement, that should be included within the witness statements, a records cover sheet, which contains this specific recommended time that the principal is seeking for the suspension, an evidence voucher if anything was confiscated, any injury reports if the behavior led to any sort of injury, any video evidence if the school plans on introducing video evidence at a hearing must be included in the suspension packet. And then other school records, such as a student's individualized education program or IEP, their transcript, attendance, any behavior reports, anything like that, that would be relevant for what's called the disposition phase, which is when the hearing office will determine how long a suspension a student will get. And so again, the school must give this to the family before the hearing. We get a lot of calls where families are saying that they're not able to get the packet or their school hasn't given the packet. What we typically do and what we recommend families do is to actually call, if you're having trouble getting the packet from the school, to actually call the supervising attorney at the borough suspension office where your hearing is scheduled. And typically they're able to help you get that information. This is what a sample records cover sheet looks like for superintendent suspensions. You'll see it has some information about, the student's grade, their credits, whether or not they have an IEP, prior disciplinary history. This also has information on any prior guidance, interventions, and recommendations that are made. And then here, and this is actually an old version of the cover sheet because you'll see at the bottom the principal's recommendation. In the current cover sheet, it contains some specific ranges of time that a student could be suspended as are listed in the discipline code. But here, the principal will put a recommendation for a number of days that they are seeking for the suspension. And then ultimately, it's the hearing office that will decide first whether or not the suspension will be upheld. And then second, if it is upheld, how long a suspension the student will receive. This is what a sample witness statement looks like. And then this is what a sample ORS report looks like. And the ORS report for us is really helpful as advocates for us to understand both, what the school's investigation was of the incident and their description of the incident, but also to determine what category of incident they're alleging the student violated, which is specifically what infraction code in the discipline code they're alleging the student violated. So here you'll see in this middle section, occurrence, when the data was entered, location, and then under category, you'll see A51, which will be the specific infraction code. And then you'll also see, excuse me, on this page, whether or not NYPD was contacted. Great. So now I'm just going to talk quickly about options at a suspension hearing. We have a whole other training about suspension hearing representation, and I would encourage you, if you're navigating this process, to either call our office or look at our Defending Suspended Students Guide, where we talk sort of in more detail about how to actually represent a student in a superintendent suspension hearing. But you essentially have three options when you first show up to the hearing that was scheduled within 5 days of getting the notice. So you can adjourn for good cause. So either the parent or the school can request an adjournment to gather evidence, contact witnesses, or to request a hearing date that's more convenient for the parent. Just note that when a parent requests an adjournment, the student stays out at the suspension school. If the school requests the adjournment, then the student is actually reinstated to their regular school. The second option is the plead no contest. This is actually how the vast majority of superintendent suspension hearings are resolved. When you plead no contest, you waive a right to a hearing. The student is not admitting to or denying the charges, but the charges as are written in the notice are sustained. However, no evidence about the incident goes into the record. And then the hearing office will just look at the charge and make a determination based on that and the record's cover sheet, the length of suspension the student will serve. A parent can plead no contest at a hearing, but then when they get the decision and find out how long their student is suspended, they do have a right to withdraw that no contest plea within 3 school days of learning the decision. And then finally, their third option is to proceed with a hearing. And again, I mentioned sort of briefly, a hearing is sort of like a mini trial. The school has the burden to prove that the behavior did occur. Unfortunately, that burden is pretty low. And so, it is often an uphill battle to win at these hearings. But we do, and again, this is where getting the suspension packet is really important because we do and are often successful when it's clear that maybe the incident didn't occur in the way that the charge is written, or there are some mitigating circumstances, and that we're able to get out in a hearing that can impact, whether or not the suspension is sustained, and then ultimately how long a suspension the student will receive. So again, if you're facing this, definitely try to contact an advocate, speak to an advocate about the suspension hearing process. So I'm going to pause for a second and just see if folks have questions. Do you see a raised hand?
I will unmute Jen.
Okay.
Okay. Thank you so much. My family is watching you as we're eating dinner.
So oh God.
21-year-old students with IEPs in the house. So I have a lot of questions. So I'm just going to ask one at a time because I don't want to hog up the mic. So I'll start with the first one, the principal suspension. You're going to hold a conference before the suspension, hopefully, probably not. If the conference, because if you have a superintendent suspension, then you will have the ability to have that manifestation determination review, and that there is like there's like directions on how you're supposed to do that. And if it was found that the behavior was because due to disability, then things have to change, things have to be done. But a principal suspension, this conference, I'm imagining that there is no specific way that you're supposed to do it. So it might not be done fairly. And if that's the case, what would you suggest that families do in a situation like that? Because a suspension is still a suspension, and the student will not be able to access his curriculum in the least restrictive environment, because he might have to go somewhere else. I don't even know if a removal, if it's for the whole day, if that's a removal or a suspension. So I was just wondering, like, if it's not done fairly, what, even if it doesn't go on a record, I don't even know what records we're talking about, but what can you do? Because it'll damage the child no matter what.
Right. So there is an appeals process for principal suspensions. Unfortunately, and we actually do a lot of principal suspension appeals, but specifically on like, process related issues. So, we can get a principal suspension expunged if the principal never came to the conference and just sent the dean or an assistant principal. If they didn't give the notice properly, or didn't hold the conference before issuing the suspension, and there was no threat of danger, things like that. I understand and can sort of relate, having been in a lot of these principal suspension conferences. It is very informal. There is less. It's harder to really effectuate due process in that setting. But again, principals do have a lot of discretion with principal suspensions. So there is an appeals process. Again, like you'll get a decision on appeal way after the student is already back in school, and so it's really, when parents call us about principal suspensions, it's ultimately up to them if they want to appeal. But, sometimes it doesn't make sense to appeal because the student's already back. Really, the conference we see as an opportunity to talk to the school about, different responses to student behavior that actually addresses the underlying behavior. And then just a note about MDRs. So principal suspensions should and could still trigger MDRs. If a student has reached a certain threshold of days, and I'll get into that in this last part of the presentation. So yeah, I guess Jay, I don't know, I can't tell who came next, but you're at the top of mine.
Sure, if that's okay. I have a question about MDR, but I'll save that till after you present on that. I guess just I was curious about superintendent suspensions, especially applying to younger children with IEPs. It's very criminalized, sort of the whole process. The documents talk about the charges against the child. You have to enter the parent has to enter how they plead.
Right.
The alternative site is extremely isolating. It's a strange site with strange people, especially for children who have special needs. They generally don't receive all their services that they're required to receive by law. They oftentimes get sent there just with a para and then don't receive speech or OT and other things they have because that school isn't equipped to provide those services. They're equipped to take care of the students that are normally in the building. So my question was just sort of about that. It usually has a negative effect. Obviously, we want to change behavior, especially behavior that, calls into question safety of children. And then the other part I just wanted to ask about is the superintendent suspension just a superintendent suspension in name only, or is the superintendent supposed to have knowledge and be aware of it being handed down and take part in that decision? Because I've specifically spoken to superintendent immediately following one of those suspensions being handed down and, to get clarity on it. And they were asking me for information as if that was the first time they heard of it, even though it was a superintendent suspension from their district.
So just to go backwards, I guess, the last question that you asked. So my understanding is, and again, I know we have a superintendent here, could maybe talk a little bit more about this, but, the suspension, the notice is actually issued from the Office of Safety and Youth Development. And so I think that it might be a bit in name only. but the approval comes from like the borough suspension directors, who I believe are all under the Office of Safety and Development. I mean, there is a lot of coordination and communication with superintendent's offices as well, but my understanding is that even though it's called a superintendent suspension, it's not as though it's like the superintendent that approves the suspension. Again, the awareness is probably there, likely, but my understanding it is the Office of Safety and Development and sort of borough suspension directors that will approve suspensions when requested by schools. Yeah, your question about sort of the process and how it can feel criminalizing. You know, I mean, yes, 100%. I think, you know, that is something that we encounter in the way that it is, yeah, the way that suspension hearings happen. And so, you know, that is why, you know, as an organization, we do advocate for, you know, the use of restorative practices and alternatives to exclusionary discipline. You know, we've been doing suspension hearings for quite some time and, you know, are constantly educating parents about their rights in the process. But yes, it's, you know, I mean, for all kids, not just younger kids, it does mirror the criminal justice system quite a bit. And I know that there are folks within New York City Public Schools that are also working to try to change that as well. And so yeah, I'm just sort of affirming that what you're saying. So yeah. You know, we have 2 more questions. I do have a few more slides left. Maybe I'm going to pause. I'm sorry, Jessica and Tamara, I'm sorry that I am going to pause right now, but please, you can keep your hands up if you want, and then I will call you at the end because I do want to make sure that I cover MDRs for folks, and it is just kind of a lot of information. So yes, all right. So just moving on quickly to talk about alternative instruction. I know, you know, both Jay and Jen mentioned this a little bit, you know, about what happens once a student is suspended. So students are entitled to alternative instruction. You know, a suspension is not meant to punish a student academically. And so they are entitled to homework, classwork, exams, and in cases of longer term suspensions, full-time instruction. And this could be at the student's school, at a different school, or at an alternative learning center. So the amount of alternative instruction they're entitled to. So during a principal suspension or while waiting for a suspension hearing in grades K through 8, they're entitled to full-time instruction. In high school, it's at least 2 hours a day. And then after a suspension hearing, all students who continue to be suspended have a right to full-time instruction. And this is all in the TANTRUST regulations, and most schools should have some sort of process set up for providing alternative instruction. And then, you know, the city has alternative learning centers that are under District 79 that provide education to students that are awaiting a superintendent suspension hearing or serving a superintendent suspension. So next, I'm going to pivot and turn to the rights of students with disabilities. So as we know from the data, suspensions are disproportionately imposed on students with disabilities. And this is true even though the law gives extra protections to students with disabilities who are being disciplined in school. And so the federal education law, or the IDEA, contains specific rights and protections for students with disabilities that are being subjected to discipline. And this includes expedited evaluations, a manifestation determination review meeting, or an MDR, which I know some folks are clearly familiar with because have already used that. Suspension plan, which explains the services or accommodations a student will get while serving a long-term suspension. And then a functional behavior assessment or behavior intervention plan, an FBA-BIP. So these are the specific protections that are listed within both the federal and the state education laws for students with disabilities subjected to discipline. So first, just to frame this, you know, who is a student with a disability for discipline purposes? So students that have IEPs are automatically considered students with disabilities, students with 504 plans as well. There's this third category that we want to make sure parents are aware of, which is students where the school should have been deemed to know that the student had a disability. And this is in very limited circumstances, but it's when a parent expressed concern in writing to a teacher or administrator that their child may need special education, but they haven't actually started the referral process. The parent requested an evaluation, so they're in the middle of the referral process, but the evaluation just hasn't occurred. If the teacher or school staff express specific concerns about a pattern of the student's behavior to their supervisors, again, this is a harder one for us to advocate for because, you know, oftentimes we don't know if this has occurred, but there might be behavioral records that do demonstrate this. And then if a child's behavior in school showed the need for special education services. Again, this is sort of a catch-all category, which allows us to advocate for some of the protections that are listed in the prior slide for students that might not actually have IEPs yet, but are clearly, in need of special education services, such that, we can argue that the school was deemed to know that the student had a disability. And so just to talk a little bit about the right to expedited evaluations. So suspended students must get expedited evaluations if at the suspension process, a parent requests an initial evaluation, or if the student is in this deemed to know category and doesn't have evaluations, but a parent's asserting their right as a deemed to know student. And expedited evaluations at the discipline process must be done within 15 days of parental consent. And then 5 days after the completing of the evaluations, the school must hold an IEP meeting, 5 school days after that. And so this really shortens the timeline. The normal timeline for referral and consent and evaluation and having an IEP meeting is 60 school days. And so this really shortens the time frame. And so we want to make sure parents are aware of this if their student does not yet have an IEP, but is being subjected to some sort of disciplinary process. So finally, let's talk about what is an MDR. So this is the main protection for students with disabilities that are facing discipline. So an MDR, or a manifestation determination review, is a meeting to decide if the student's behavior was caused by the student's disability or a result of the school's failure to follow the student's IEP or BIP. And if the answer to either of those questions is yes, then the student cannot be suspended. They must return to school. And the school must do a functional behavior assessment or an FBA and a behavior intervention plan or a BIP. And if any of the answers to those questions are no, then the suspension would continue. But the school must still create that suspension plan, which will discuss, what types of services and accommodations the student will receive while they're serving the suspension. And then they could still consider doing an FBA or BIP when a student returns to school. It's important to note that, and we advocate for families quite a bit in these meetings. And when we're talking to schools, it's not that a student with a disability cannot be suspended it's not that a student with a disability cannot face consequences for their actions, right? It's just that the consequences must be appropriate if the behavior is due to their disability. And so if the behavior is, again, related to their disability, then any sort of consequence or any sort of reaction, must actually address the student's need and not just serve to exclude them from the school community. And so that's where, we try to stress that and make sure that that's clear, that this is not about a student, not having a consequence or sort of like not being allowed to be disciplined. It's about making sure that the disciplinary response is appropriate to meet that student's particular needs. So when must the school hold an MDR? And this goes to your question a little bit, Jen. When the student is suspended for 11 or more days in a row, an MDR is automatically triggered. And so if a student gets a superintendent suspension, that will automatically trigger an MDR. There will be the date, time, and place of the MDR will actually be in the superintendent suspension hearing notice. If a student is suspended for 11 or more days within a 40 school day period, then they are also entitled to an MDR. And so this is where, it's important to note, like if your child was removed from class a number of times, if they received principal suspensions, if those add up to 11 or more days within 40 school days, then there should be something within the suspensions database that notifies the school that they must conduct an MDR. Again, if some of these removals are not necessarily categorized in the way they're supposed to be, or they're illegal removals, then that might not get triggered. And that's where we can help advocate with a family to get an MDR if they've been removed or suspended for this period of time. And then finally, when a student is suspended for 11 or more days within a school year, and there's some sort of pattern of behavior, then that's again another point where they can be entitled to an MDR. So what happens at an MDR meeting? So the MDR team usually contains at least one person from the school that has knowledge or can at least interpret the student's behavior. So that's typically a school psychologist or a school social worker. And the team will look at the student's IEP, their FBA, BIP if they already have one, any evaluations and teachers' observations, occurrence reports. A parent can bring in records. And so we often will advocate at meetings and have records from outside therapists, outside providers talking about a student's diagnoses and their behaviors, and then any other relevant information. And then essentially at this meeting, the school must follow this worksheet, the MDR worksheet, which really goes through all of the documents, tries to identify a disability-related behavior, identifies, the behavior the student engaged in, any triggers, and then, it sort of prompts the team to discuss and determine whether or not this behavior was or was not a manifestation of the student's disability. Some tips that we give families for preparing for MDRs. So reviewing all of the documents, making sure, that you sort of pull out and discuss any disability related behavior from those documents and bring it up at the meeting. Making sure that, your child is actually getting all the services on their IEP. Again, it's not just about whether or not the behavior was related to the disability, but also whether or not the student was getting the services on their IEP. So we've had circumstances where a student was supposed to have a para during all class periods, and then the para wasn't there at the time of the incident, right? And so that is a situation where that is a manifestation, and they should not be suspended for that incident. And then finally, our biggest tip is to really ask for outside providers to participate, folks that work with your child outside of school that really know them and their behavior. They can either participate or write a letter. Oftentimes in these meetings, it can feel a little bit overwhelming, where it's just if it's all school staff and a parent advocating for their child, it's helpful to have, folks that can talk about why they believe it was a manifestation and describe other similar incidents or explain, a student's diagnoses, things like that. And then finally, I just want to mention, and this is going to be such a broad overview of this, this assessment, although this is sort of the key support, behavior support for students with disabilities under the IDEA. But if the behavior, again, is found to be a manifestation, or even if it's not, the schools really should be doing some sort of FBA or BIP when a student is engaging in behavior and they're being disciplined or suspended. And so an FBA is a special education assessment that serves to identify a specific behavior, so what behavior needs to change. And then an assessment is done that asks the questions: when does the behavior occur, where, how often, for how long, in order to determine the function of behavior. So why does the behavior occur? And then once an FBA is done, the team must use the FBA to create what's called a BIP, or a behavior intervention plan, that will prevent and address the behavior and promote positive behavior. So this is not simply a behavior contract. This is not simply something that says, a student must not engage in X behavior. It must include information about when and how often the behavior happens and how severe it is. It must include specific strategies for stopping the behavior from happening, which could include, classroom changes, a new school schedule, having additional support staff like a paraprofessional, a safety plan for how to manage the behavior when it does happen, such as calming the student down, removing the child from the classroom, if appropriate, having the child speak to a trusted adult. It could also list specific school staff who your child trusts will be designated to work to support them. And then most importantly, it must measure progress. So there has to be a schedule to mark progress and set future meetings so that parents can remain up to date about how this plan is working. And if it's not working, then it must be changed. For us, a BIP is only really as effective as how it's being implemented. And so, really trying to assess and talk to school staff about whether all staff who interact with the student are fully implementing the plan. And if not, advocating for school staff to get coaching and implementation support. Again, if with proper implementation, the student is not progressing under the BIP, then that might mean that it needs to be changed. All right. So those were the supports for students with disabilities. That ends my presentation. I'm going to go back to the Q&A because I know there were a few folks that I missed earlier, and then a few extra hands, as well as some information in the chat. So I don't know, Gavin, how you want to do this. I think before I go to turn to answer questions, and I can stay on as long as folks need to answer these questions, I just want to make sure you have, this slide has our information, our helpline information, as well as an email address. You can email if you have questions or are navigating a school discipline issue. And then I also ask if you have time to complete just the short training survey. There's a QR code here, which helps us gather data and assess, how helpful or unhelpful these trainings are and if we need to make any adjustments. Yeah, so with that, I will pause and I can answer any questions folks have.
And maybe we can go to Tam, Ellen. I'm just reading from my screen down. Tam, Ellen, Jay, and Jessica.
Hi, thank you so much for this information. And I wish that every parent had this access, right? Because schools don't give it out a lot of the time. So it's a matter of, do you know your rights? Do you know the system and which parents know it? And it's just so ridiculously sad what I've seen happen over the past several years, just working as an advocate in this space. And I'm more concerned, honestly, about the unofficial suspensions and classroom removals that I know are rampant, particularly in District 2. It's a big concern when you don't have the services that you're supposed to have, and therefore your behavior, you escalate, right? If you're a kid who needs ICT and you have 3 core academic courses across a year where only 80% or 80% of the time there's no co-teacher in that classroom, then you don't have access to the material, right? And so kids are being sent out of the classroom. They're not being given small group instruction. They're being given a babysitter. They're going to the assistant principal's office, a counselor's office, sometimes just a room with an adult in it. Their parents are not being notified that they're missing instructional time, and it's not being made up. And that affects their self-esteem. It affects everything. And that's not on the kids. That's on the school. Like, those are mandated services that need to happen. I mean, the para piece is just another part of the disaster, right? You have a para and it's being shared with another classroom. That person's going away. But my concern is what's the reporting around that? Like, because these parents that I've worked with have no idea unless their kid tells them. And what they say is, I got in trouble, right? Not my para wasn't there, my speech push-in didn't happen, there's been only one teacher this whole time in math, science, and ELA, right? And so you see them leaving all the time. And so I'm curious what sort of responsibility the schools can actually take, because I know that I'm well informed and it's hard as hell to advocate for kids, like even knowing all of this stuff. And the other thing that I just wanted to ask you really quickly is, it seems like schools are not exhausting and the full range of remedies that are available under IDA and through the DOE first before they offer or suggest very straightforward, this is what we're going to do next. And it's harsh, right? A lot of times it's lately, I'm going to be honest, I have 4 students I'm working with that are at Bellevue and they're under the age of 11. It should never get to the point where you're an elementary school student, you haven't received your services, you're not in the right classroom designation, you don't have a para, the school doesn't know what to do with you, and you get to a point where your mental health declines so much as a little kid that you end up in a psychiatric ward, a hospital, a PHP program, and then the school doesn't even want to take you back. So how can we tell parents, and how can we make sure that our schools are doing things like an FBA and a BIP as a preventative measure, not as one that happens after the kid has escalated and is missing crucial instruction time. And parents don't know you can ask for those. They don't even know what the hell a BIP is. They don't know what an FBA is. They also don't know that you can request it at any time. You don't have to wait for an AP meeting or a triennial. The second piece is they don't know they can request a psychiatric evaluation and that it can be paid for by the DOE, and it should be. And that's a very common thing that helps build an FBA. And you can also get a 504, right, for mental health related accommodations, which parents don't know about. So what can we do? I think that it's just a constant fight, but it seems like some schools do a much better job, and that the teachers and support staff take their lead from the leaders in the school. So when it's a top-down issue, I just feel like we're at such a loss, because like that's the modeling that they're being given. They're given a message that they can cut corners, but these kids are feeling it. I mean, the mental health of our students with disabilities gets ignored a lot of times, right? So that was kind of a meandering rant, but I'm just like, it's just breaking my heart to see what's happening.
Yeah. I mean, I hear that, and I certainly don't have, I don't have a clear answer to it, because they're like, other than, what Advocates for Children tries to do is really educate parents about their rights in this process, and, making sure that parents are empowered and understand that all these things that you're mentioning, that this should be a preventative, like these things can be put in place, should be put in place ahead of time. Things like when we see illegal removals happening, really questioning, school staff and saying, like, is this a teacher's removal? Like, are you logging this as a teacher's removal? Is this a principal suspension? Like, is the student being suspended? Is my child being suspended right now? Really pushes schools to think and reevaluate, okay, like, can I do this? Should I do this? Pointed to the Chances regulation about EMS calls. It was just amended last summer. The language in there is pretty strong and supportive of families of young people that are in crisis in schools. And so, again, pointing to that language and saying, like, have you done this? Like, where's the crisis team? Have they intervened? Have they, again, like, a lot of it is just awareness and knowledge and empowerment of families to know their rights and to exercise them. I mean, certainly I'm sure there are ways to reimagine, like, the delivery of special education services and the delivery of the system itself. That's sort of beyond the scope, obviously, of this presentation and of what we can do. But that is something that, there certainly are better ways. There are ways to push schools to actually provide students with, with the supports that they need. And so certainly at AFC, like, those are just some of the things we do, is really point to parents' rights and say, this is like, what is this removal? What is this? What are you categorizing this as, for example, and sort of really pushing schools to identify that. And again, like, understanding and appreciating that these can be difficult decisions by schools and school staff in the moment when a crisis is happening or an incident is occurring. And then really advocating, for more support. We often will help schools, advocate for more support from Central, right? Like, if a student needs more support, we will file impartial hearings to get additional services for students in schools. And so it's a range of things, but I think it really starts with parents, like, knowing what they can ask for and how to advocate. So.
And knowing that you're there, because thank you, by the way, I've called your helpline at least 50 times. I'm not even kidding. And there's always somebody willing to help and dig in. And I really appreciate that. And I'm going to just share your number with everybody I know from now on, if that's okay.
Yeah, of course. Of course.
We go to Ellen.
In comparison, this is very quick. Once the evaluations are signed off on, once the parent agrees to the expedited evaluation, is it 15 business days or 15 calendar days for the eval?
For the eval, I believe it's 15 school days. So it's the same
So it's school days.
Business days. Yeah, it's school days. It's school days.
So it would include vacation time or anything? Thanks.
It would, yeah, it would, yeah, it would not include school holidays. Yeah.
It would not, or it would?
It would not include the 15 days, yeah, because it's 15 school days. Yeah. And then 5 school days after that, they must have the IEP meeting. So.
Thank you.
Yeah.
I think I was next. I just quickly, I just want to echo kind of what Tamara said, just quickly, about the concern about the unofficial suspensions. That been the being called to bring your child home for undesirable behavioral action, that's rampant. We're just seeing a ton of that. A lot of use of like safe room, save room as a consequence place, not only because a child is in crisis, but as you did this today, we'll have that space available in 4 days. So your child will spend a day or two there in isolation. So that's just one thing I just wanted to mention, just echoing what Tamara said. It's rampant. I know you refer to those as illegal removals, but they're happening constantly. Just with the MDR process, I know that for children with IEPs, the MDR, I know there's those thresholds that trigger them. There's language about when they hit these thresholds for a number of removals within 40 days and things like that, that the language states the MDR should happen before the removal, but it still always is scheduled later. And whether it's the first suspension or it's one that technically, according to that language, should happen sooner, the suspension office always schedules. I know the law requires the MDR to happen within 10 days. It's always scheduled at 10 days or the closest weekday that will comply with it. So if the 10 days would be a Saturday, then it'll be the Friday before it'll be 9 days.
Right.
And I've spoken to the suspension office, they say that it's computer generated. So the computer generated system basically just does it the max under what state law requires. And then what happens at the MDR, oftentimes parents are told by the school, this is a superintendent suspension, and we know it was a manifestation. We have to go through this process. We will say it's a manifestation, and your child will be, reinstated immediately. They get suspended though during that time frame, and then you have the manifestation determination review, and it comes out, it's determined it was a manifestation, and then the suspension office officially declares it such after that meeting and says, by law, we're not allowed to suspend the child after they've been suspended for
Right.
a week and a half, 2 weeks. And I'm a CEC president, and we had folks from special education, DOE Central Special Education at a meeting presenting on MDRs, and we brought this up, and they said it doesn't compute. There's a problem with the law and the suspension office, and they're trying to work with that department, but it seems like nothing has changed, and they're still in this space where they say it doesn't compute. So, I didn't know if you had any thoughts on that. And also, just in the future, if you could let me know how my CEC can coordinate with you and have you to our meeting.
Yeah. Yes, definitely. Well, yes, I can leave my email in the chat and you can reach out about that. But yes, I like sort of the systemic issue of MDRs and the timing where it sort of gets like it's almost like like even if it is a manifestation, you still are able to exclude a student from school for that 10 days up until the MDR happens. It is unfortunately like there's not much we as individual advocates can do to change that. I should say that there are folks within the special ed office that I know that, I'm sure if it sounds like they presented to you, but that are working on MDR related issues. And so if there are issues where maybe you're trying to advocate for an earlier MDR, you could potentially, escalate to the special education at schools.nyc.gov email address and try to get, the person within within the special education office. Stephanie Jamilo is the one who we communicate with the most, who's sort of like looking at this issue. And so I think, I can't, there's not much to say, unfortunately, that is sort of like what they're allowed to do under the law. But, the spirit of the MDR and the idea behind the MDR really should preclude that, right? Like it should happen before a student is actually suspended or removed, because the whole argument is that, that is not actually addressing the underlying behavior. So I hear you. Yeah.
And the suspension office did tell us, I spoke to an officer from the suspension office recently, and they said that the suspension hearing date gets set, it's computer generated so many days out, and then the MDR 2 days later, but it all backed up at the end to the MDR being as late as possible allowed under the law. But also, if the parent guardian enters a no contest plea and waives the suspension hearing immediately, so that suspension hearing that might be 5, 6, 7 days out from the suspension notice, and they waive it immediately, the dates aren't changed. There is no expedite. At that point, there's no, the MDR will take place at the school. The suspension hearing office is supposed to coordinate, be informed of it. But at that point, the MDR just logistically should be able to happen very quickly.
Right, right.
They do not,
Yeah.
and the suspension office is the only one that could actually change that date, and they will not.
I mean, we've had some success with on like the individual school level of just asking for a more like a, you know, once the no contest plea is entered for a, you know, a to reschedule the MDR, because the date on the hearing notice really is, you know, it's like a recommended date, but it, you know, like if the parent's unavailable for that date, then the school must work with the family to like reschedule. I mean, the parent's entitled to be there. And so it really is, it might be possible on a school level to get that rescheduled sooner, just to have the MDR. But again, like if a school is doesn't really want the students to be back in school and knows it is a manifestation, then that, you know, that might obviously change the motivation in terms of flexibility with scheduling. So again, these are sort of systemic issues that I know that, you know, folks within DOE, New York City Public Schools and Central are looking at and working on. So
Thank you.
yeah. I think Jessica.
Thank you. This is great, Rainey. Thank you. I have a couple questions, but the first two have already mostly been touched on, so they should be quick. And maybe if it's okay, this is perhaps also a question for you, Kelly. The first question was, what kind of oversight occurs in schools to ensure that the BIPs are getting created and being implemented properly? Like, is there a particular protocol and we're just falling apart on the implementation? Is there something written that or isn't written that would be helpful to ensure that this is occurring more regularly?
So so there is very little oversight on the BIP process. And, you know, it is something that it is, again, like the main protection, the main, you know, source, the main support that we can advocate for when a student's having behavioral challenges. But I say that at the same time, know that it can often not be effective because of, you know, both how it's created and how it's implemented. I should say that, you know, we do know that within Central, I mean, just on a policy advocacy level, like we are always advocating for funding for, you know, there to be behavioral specialists in districts or for school staff to have access to behavior specialists who can work with them to create quality FBAs and BIPs. But yeah, but that obviously doesn't exist right now. And so, however, if a family does, if a school has created a BIP and it is a special education, you know, an FBA is a special education assessment, if they disagree with it, like both the categorization of the behavior and then the, you know, the actual strategies that are in the BIP, then they can disagree with it and request an independent assessment authorization for an outside evaluator to come in and do that FBA BIP with the school. And once that process is started, once a parent asserts their right to disagree with an evaluation and ask for the independent assessment, it's more often than not that those are granted, because in order for a school district to deny that, they actually have to file a hearing themselves and say why and defend their evaluation, essentially. And so what we will advocate for often when a school created BIP is not appropriate or just not working, is for that assessment authorization to then go outside and get an independent provider to provide that BIP. Yeah, so that's sort of like I mean, again, like not accessible for everyone. I mean, that's
not that higher level of like, did this already?
Right.
Okay.
Right.
Thank you. And then next question was, do you happen to have any data on the number of legal removals that are occurring? Do we have any sense of, when everyone's saying anecdotally this is happening a lot, what that actually looks like?
I am not aware of data collection. I guess Kelly, you might you might be aware of that, but
yeah, it requires a little bit more digging, also because removals are often initiated by teachers. Teachers have that in their contract to remove a student from their class for that period. But it is something that I can find.
Thank you. Sorry, one more question. But Renee, I would just, I guess, ask you, you know, we know you shared data that we know that Black students, students with IEPs, and those in temporary housing are disproportionately receiving suspensions that are receiving higher rates. What would you say to somebody who says, well, sure, that's because that group of students are displaying behaviors that require suspensions at higher rates? Could you share with us maybe just some information, how we could help parents advocate and counter that kind of statement or argument?
I mean,
That's hard. Sorry.
Yeah, no, you're fine. You're fine.
But there may be data perhaps that.
I think for us, it really is that the data and the information about really the ineffectiveness of exclusionary discipline and suspensions generally. I mean, they just do not change behavior, and the negative impact is pretty significant. And so, I think it's really difficult for parents that are navigating the public school system, especially if their child is being subjected to behavior or things like that, to sort of jump to, okay, like the student just needs to be removed, or I just need, I just want my student to be safe, and like we understand and respect that. But I think for us, what we're advocating for is for actual, evidence-based responses to behavior to actually improve school communities and change behaviors. I mean, these are all, it's all kids. Like they're all young people, they're all kids, and they all sort of obviously deserve a chance to get the supports and interventions to actually address underlying behavior and have their needs met. So yeah, I don't know if that's like exactly responsive, but that's sort of the angle and how we advocate, especially within school settings, because again, like we can understand, and we represent certainly families of students that are being suspended, but also, a lot of families of students that are being, subjected to different types of behavior, bullying behavior, things like that. And so we sort of, and oftentimes those, it's the same kid, right? It's the same kid that is both the target and potentially the perpetrator of these acts. And so it's sort of, it's the idea that exclusion is going to help the situation or really change school climate and school communities is something that I think is pretty well established to not be the case. And so, yeah, that's what we focus on. And I can try to pull some of those studies. There's lots of national studies about the impact of suspensions and exclusionary discipline and sort of both the harm and then also the ineffectiveness in terms of actually addressing school behavior. There's both national studies and then, like the New York State Education Department has issued a number of reports. The Board of Regents has issued a number of recommendations regarding exclusionary discipline and really like emphasizing that long-term suspensions do not actually address student behavior. So.
Yeah. Absolutely. I guess I think I just don't have it now, but there's data also to support, for example, that some of this has to do with how behavior is being interpreted or, how how discipline is being enacted with different groups of students as compared to behaviorally what is actually going on. Right. So if there's any of those studies that you can share too, that would be great.
Yeah, definitely. And you'll see some of that in the code. Like if you look at the different infractions, I mean, a lot of it is about obviously perceptions of behavior. And so there's obviously a lot that goes into that. And so how behavior is categorized and how, what type of suspension is being issued, there's just a lot of factors that come into play there. So.
Thank you.
I think next we'll go to Mark, Jamie, and then Anita.
Thanks, by the way. Ms. Singh, Mr. McGuire, et cetera, everybody. Thanks. So listen, my child's suspension happened some time ago, right before the Christmas break. A very rushed, what do they call it? Investigation. But that's kind of blood under the bridge. I guess going forward is I'm trying to just concentrate on the expungement, and if there's a way to do that smartly. And, I guess the last question I really have is, can I set up a meeting with your office, Ms. Singh, because it's been very helpful. And I won't bore you all with the details everybody here covered the ground very well.
Yes, you can definitely reach out to us. The sort of typically for families, we have we have folks reach out to our education helpline or at our info at Advocates for Children. Since you all are here, I'm going to put my email address in the chat, so feel free to reach out to me directly. I can try to talk you through your specific issue. So yeah.
Thank you.
I think Jamie, you're next.
Hi, thank you so much for this information section. It's super helpful. So my question is, I'm a parent from the District 2, and my question is like, what's the right way or procedure if we think the principal is not actually doing her job? Like our child is actually from grade 4th. I think he's diagnosed with the disorder. I think it's partially also because of the punishment from the school. And then, yeah, so I was wondering, like, if he was like scared of principal, being dreamed of being yelled at, and also being punished negatively. The principal is not following the doctor's note to be a bit more like positive reinforcement. And what she cares about is really pushing for her academic agenda. So not really like caring for the student, but caring about how like she could best do her job, like to as administrator. So I don't see any interest of her like really thinking about the child. So so my question is really like in this case, if we have questions about the principal and her, her behavior or conduct, what would be the right way? Thank you. Appreciate it.
Yeah, I think it looks like Kelly put this in the chat, but I was going to say that, I mean, for us, what we advise families to do is to reach out to the superintendent's office, who is there to support families. But you could also reach out to me. I mean, I don't know, your child's specific circumstances. It sounds like it's been a struggle, but if there are other things you could be advocating for or things that, I can suggest to you, I'm happy to talk through that. So if you can also reach out to me, my email's in the chat. And yeah, I can try to see what advice we can provide, but certainly it sounds like Kelly also put his email address in the chat. So
thank you so
reach out
much
to him as
both.
well. Yeah.
Thank you so much both. Thank you, Kelly.
Thanks, Jamie.
I think Anita had a question.
Hi, good evening, everyone. I joined very late because I came aware very late. So I wish I didn't miss a meeting. My goodness. I'm hoping maybe I can get a recording. So to piggyback off of the question that was displayed earlier about suspensions, one of the issues, I'm a 7th grade parent, and I'm also the 7th grade representative class parent, and one of the issues that's arisen is that because there is such a pressure, for lack of a better word, for the principal to lower the suspension rates in the school, what's happening is there's one particular child who doesn't look like a child. He looks like a really like senior in high school. But anyhow, he has been constantly disciplined, makes a lot of racist remarks, very disruptive in the class, and has insulted my son badly. Middle schoolers, they can really get to the core, but he is exceptionally so, does a lot of racial slurs, and has just really affected the energy of the class. Teachers are ignoring, they're not always documenting what's happening, calling kids by their race, in a very rude, derogatory manner. So what is the process? Like, I've set up a meeting for our class to meet with the principal, but what can be done? Because our teacher is basically, the principal is basically saying, oh, well, he just puts his hands up in the air saying the parents don't want the child to leave because it's a very good school. And I know that it's a journey to go through the school, and I know that I'm empathetic towards this particular child, but it has tremendously affected and disrupted our class. I hope this is relevant to what we're talking.
Yeah, I mean, it's definitely relevant. And I think, I mentioned that we sort of work with, young people both that are being suspended, but that are also sort of, in a situation where it's I wish I don't have like a very clear answer here. I mean,
Yeah.
both sides have rights, right? And like we really try to emphasize and focus on parents' due process protections in the suspension hearing process, because I think mostly what we see is sort of, maybe not the situation that you're mentioning. But in the situation you're mentioning, it sounds like you're doing everything that you could potentially be doing.
No, I'm sorry,
Yeah,
the dean
yeah.
and everyone, they don't even call the parents to let them
Okay.
know what's happening. And number two, like I'm sorry, a Black brown child, and he is insulting fellow Black brown students. And they are being told the message to just ignore or shut it down or don't pay attention. Basically, I don't like that either. That message really bothers
Right.
me, that
Right.
they have to learn to tolerate this. I mean, this
Right.
is not appropriate.
Right.
Yeah.
Anita, I'm not sure if your child's in a District 2 school or not, but I'm gonna just re-put my email in the chat so that I can reach out to you individually to check in on what's been happening at the school.
Oh, it's District 5, and I'm in District 3, so but we're all friends.
Yeah.
We are.
I can say, Anita, that, something that we really advocate for, and I don't, this is maybe, I don't know if this will help in this immediate situation, but, you know, while we don't sort of, support like excluding students excessively, like, I think what we emphasize really is this use of restorative practices. And I think the idea,
Yeah.
like sort of that strategy that you're mentioning, where it's just telling young people to ignore behavior or to like let it go or something like that, that's really
Not addressing it.
not
Not
addressing it. Yeah.
acknowledging.
Yeah. I think the key thing is, I think the way, yeah. I mean, and, a lot of this has to do obviously with the administration and the way things are funded. And, I don't necessarily need to get into all of that, but certainly what we try to do is advocate for restorative practices in these types of situations, because again, a lot of it is just about young people not understanding the harm that they're causing. And restorative practices really gets at the root of that. It's like understanding that you're in community with other young people, with the school as a community, right?
Yeah.
And you need to be, there are consequences for actions. And you sort of need to understand the harm that you're causing. And so that's where restorative practices can really make a difference. Again, I don't, like if your district doesn't have it, then it's kind of hard to know, but it could be something you can ask the principal or your
I've heard of it.
superintendent. Yeah.
It's there, but I don't understand how formulated it is.
Right.
Also, thank you, but I want the person that had a question before about what to do. I encourage connection via the 311 line. And I can put it in the chat. It's called a DOE escalation line. So she can connect via 311, and then they have a parent engagement line. And that, I filed 2 complaints, one about this, and it gets sent to the family support center in the district, and they handle it. They have to handle it. They have to handle the complaints. So that's the avenue. I can put it in the chat. But thank you.
Thank you. I think we have a question from Sonal, and then if we have a moment, another question from Jen.
Hi, Rohini, how are you? So I am a former Advocates for Children staff attorney, and I just want to say you guys are so amazing, and thank you for being here and sharing with us all. I also sit on CECD2 with Gavin and Jessica and Sarah, and I was not able to join our call, but I do have a question, and maybe it's more policy, but we talk a lot about sort of disparities and suspensions based on race and class and housing. and the data is there, and the data is great, right? But you know, what it shows is sort of undertones of racism, classism, xenophobia, right? You know, the ways in which we perceive behavior from a Black child versus a white child, even if it's the same exact behavior. And I see a lot of this in our school. And so I'm curious, outside of studies, outside of the data, I mean, do you have any thoughts on, you know, sort of the root causes of why we're seeing these disparities? What kinds of literature is out there? Because I'd love to see some of that, but really sort of understanding, not just saying, yeah, this is what's happening, students with disabilities and Black kids and whatever, but like why, and you know, are the adults making those decisions trained, right? Like what is really the cause of, and how can we move towards a better solution to some of the disparities and suspensions?
Yeah, and you know, again, I think that there certainly are studies about, you know, like how perceptions of behavior and implicit bias and how that can play a role. There are also, you know, lots of studies about just like generally how maybe not in New York City, but like how school systems approach behavior, just general like, or I think that, you know, schools sometimes schools, or and I think this was mentioned also by one of the parents that was talking about their struggles with the principal, you know, the focus is so much on academics and maybe less on social emotional functioning and behavior. And I think for us, you know, the way we experience it and the way that we talk about it is that, you know, this is part, you know, students are like, our young people are learning how to be citizens, like within school, they're learning how to interact with other people, they're learning behaviors. And so like it's important that schools are intentional about how they approach that, and not just kind of like let things happen and not, you know, try to foster and build community. And so I can try to find some of that and send it to you. But yeah, I again, it's there are so many factors that are involved. But there are, yeah, like it's hard for me to identify, like, you know, and there certainly haven't been, I'm not aware of studies within New York City about like why these disparities exist within New York City public schools. But just generally, like I think the APA has, like American Psychological Association has studies, like again, I mentioned like the Board of Regents did a whole review of suspension data and came to some conclusions about discipline. And so yeah, so I'm happy to share that. I can try to compile some of that and email you. Yeah.
Jen, maybe we'll take your question
Yes.
with the last one.
Thank you. I just didn't want to. I can ask 20 questions. But you know, I once had a situation where a second grader was handcuffed. An autistic second grader was handcuffed with Velcro handcuffs because he was having a big, huge meltdown. Um, and you know, and the ambulance came too, or police, whatever, EMS. So you know, and there was a phone call to the parent to, you know, I'm doing this now, you know, so the parent could have tried to pick up the child and take them home. So this sort of got me thinking about, you know, what you had said about illegal removals and how so many parents are faced with the phone call of your child is having a day, you got to pick them up. And so parents, if they did know that you're not, that the schools are not allowed to do that, how can, how would you want the parents to respond? What would you want them to say? And then just to like throw it in a little ringer, you know, what if the threat of EMS was at the tail end of that come pick up your child? So like not every come pick up your child phone call is going to have an EMS threat to it. But you know, so it's like a two-part question. Sorry.
Yeah, I mean, I wish I could say I haven't. I have had that conversation many times with families, and I think, you know, if there is no threat to EMS, then I think our response is, you know, pretty much like, you know, why is this to be removed? Like, is this a suspension? Is this a removal? Sort of some of the things I was saying before. Obviously, if there's a threat of EMS, I think, you know, the questions are more like really pushing them on like, what did they like, have you, you know, looking at the Chancellor's regulation and looking at the steps schools need to take, and asking them, did they do these, it says very clearly in the updated Chancellor's regulations that schools cannot use the threat of EMS to get as a disciplinary response, right? And so pointing to that language and saying that, you know, and I say that, but at the same time, you know, obviously parents are going to make their decisions. And I, you know, like me as an advocate in the moment can't stop a school from calling, like once that 911 call is made, they have to come, you know, they have to do their assessment, like more likely than not, they would, yes, exactly. And so it's just, it's like obviously it's a parent's individual decision, you know, like whether or not they want to take that risk. But I should say that like you know, you don't want to like be there trying to call the school's bluff and then having them call EMS and having your young person in that situation. And so, but the language is really strong in the Chancellor's regulations, and I think really emphasizing that. And then, you know, making sure that once that happens, if that happens once, like it shouldn't be happening continually. Like clearly the student or the school needs more support. And so that's where we really try to step in and, you know, immediately like escalate to central, get someone into the school to provide more support, you know, advocate for like an immediate at-risk paraprofessional, like, you know, all the, you know, really activating like the special education rights of the family at that point, is really what we would do. But yeah, that would be my response. So yeah.
So I just want to thank Rohini, and I want to thank Kelly McGuire. I want to thank all of you, my fellow CEC2 members, fellow CEC21 members, and and Victor is our administrative assistant, has been very, you know, graciously, you know, set up all the technical aspects of this Zoom, and so we're appreciative of that. I feel like we could probably go on much longer, but I'm mindful of that we are relying on the sort of the we are the sort of the volunteer efforts of of Advocates for Children, and they have some great resources on their website. I've looked at a lot of the videos and slides that they have posted there, which I think are really helpful. We will post this video and I think slides for anyone. And I think Kelly McGuire, our superintendent, left his email. I left my email in the chat. I think there's some other resources in the chat. So I just want to thank you all, and especially thank Rohini Singh and Advocates for Children for sharing their expertise and their time with us tonight.
Thank you all. Good to meet you. Bye.
Thank you. Good night.
Have a good night, everyone.